Hello and welcome to this webinar on how businesses can manage the impact of Covid-19 on their financing arrangements. My name is Marion MacInnes. I'm a partner in Brodie's Banking and Finance Department, and I specialise in leverage financing and real estate finance transactions. We recognise that this is a very challenging time for many businesses. The Covid-19 pandemic and the efforts of the UK and the Scottish governments to help stem the spread of the virus through business closures and social distancing measures has resulted in a number of businesses experiencing a significant reduction in cash flow and operating income over a very short period of time. The economic shock has been felt by some sectors more than others. However, it is clear that many businesses are currently experiencing the high economic impact phase of the pandemic, and this may have knock-on implications for the business's financing arrangements. In this webinar, I would like to cover three topics. We will cover the impact of Covid-19 on existing loan agreements, and we will look at relevant provisions of financing arrangements which may be breached as a result of the social and the economic consequences of the pandemic, and which borrowers and lenders should be aware of. We will also cover some of the practical considerations for borrowers. For example, if businesses are seeking waivers or amendments of existing loan agreements, or indeed for obtaining new funding to cover short to medium-term cash flow and liquidity requirements. Finally, I'd like to touch briefly on some of the government funding schemes which have been introduced to assist borrowers to weather this high economic impact phase of the pandemic. So looking at the impact of Covid-19 on existing loan agreements. Although some high street lenders do use bank standard form loan agreements for certain categories of customers or for levels of funding up to a certain level, it is rarely the case that two loan agreements will be identical. And so it is important that businesses do carefully review the exact terms of their loan agreements in order to identify if any issues may arise in the coming weeks and months as a result of the economic impact of the pandemic. I would recommend that early legal advice is sought where required in order to assist with this review. At a high level, however, common provisions of debt documents which may be breached or triggered as a result of present circumstances and which may cause issues for borrowers and concerns for lenders include the representations and warranties. Common warranties which may be vulnerable to breach as a result of present circumstances include, for example, representations that there has been no material adverse change to the business or to the assets or to the financial condition of the borrower or the group of companies to which the borrower forms part since delivery of the most recent financial statements to the lender, and representations that there has been no default under the loan agreement or that no event or circumstance exists which would constitute a default or a termination event under any other agreements or instruments to which the borrower is a party. It is worth bearing in mind that the occurrence of a default under the loan agreement or the breach of a representation or warranty may have the effect of preventing further utilisations or drawdowns under the facility agreement, thereby restricting the business's ability to access much needed cash flow and liquidity at this time. It's recommended that businesses check the undertakings and the covenants in their loan agreements. Again, common covenants which may be vulnerable to breach include restrictions on the business's ability to obtain further indebtedness without the lender's consent. This may be particularly relevant at this time if the business requires access to additional working capital or liquidity facilities, or indeed if the business is looking to take advantage of some of the government funding schemes. And in either case, the proposed lender is not the business's current lender. The facility may contain obligations which require the borrower to ensure that either the borrower itself or third parties comply with key transaction documents. So in the context of a trading business, for example, the undertakings may extend to ensure that the borrower itself or an operator, supplier or a distributor complies with the terms of a material operating agreement or supply or distribution agreement. In development financings, this may extend to ensuring that the building contractor complies with the main building contract or the other construction documents. And in a real estate financing, there may be obligations to ensure that tenants comply with lease documents, and in particular, the obligation to pay rents. Business closures have resulted in a number of retail tenants being unable to meet their rental payments as they fall due. An agreement with a tenant to reschedule rental payments or to delay rental payments may constitute an amendment, variation or waiver of the lease document. And businesses should bear in mind that it's often the case that such arrangements require the prior written consent of a lender. Financial covenants. Facility agreements often contain financial covenants which are there to assist the lender to monitor the financial health of the borrower. And they often provide an early warning system for lenders should the borrower be facing financial difficulty. A breach of financial covenant may constitute a drawstop under the facility agreement and will often constitute an event of default under the loan agreement, which would entitle the lender to accelerate repayment of the loan, or if the loan is secured, to enforce security. Reduced cash flows and operating income at this time could have an adverse effect on EBITDA, for example, if testing leverage ratios or if testing interest cover or debt service cover ratios. Similarly, asset values may be impacted at this time, which will have a knock-on impact on loan-to-value ratios. Businesses should check the precise wording of the financial covenants in their loan agreements. Is the covenant tested on a historic or look-back basis? Or is it tested on a projected look-forward basis? Or indeed both? What income requires to be excluded from the calculation of the covenant? So, for example, for a real estate finance transaction, it's quite often the case that rents under lease documents where the tenant is in rental arrears for a certain period of time requires to be excluded. Check whether the facility agreement would permit an equity cure, such that a breach of covenant may be cured through the injection of additional equity or subordinated debt by the parent company or by a sponsor. Finally, consider what effect the incurring of additional borrowings, if required, may have on ongoing covenant compliance. Business should carefully check with information undertakings in their loan agreements and the ability of the business to comply with these. Quite often, loan agreements will require the provision of information regarding the financial condition, the assets and the operations of the borrower, promptly following a request by the lender. There will be an obligation to notify the lender if there has been a default under the loan agreement, and also an obligation to notify the lender should there be any material breach of transaction documents. Borrowers should check the information undertakings in their facility agreements and check whether any information undertakings or reporting requirements have been triggered as a result of the impact of the pandemic on the borrower's business. Facility agreements also often include events of default. The occurrence of an event of default would entitle a lender to accelerate repayment of the loan and, as I mentioned, enforce any security which secures the loan. Typical events of default which could pose a risk for borrowers in the current climate include non-payment, for example, due to a decrease in cash flow or operating income, breach of some of the representations and warranties which I've covered, Cross-default, this is where a default under other borrowing arrangements has the potential to trigger a default under the main facility. The loan agreement will often include insolvency events of default, and these insolvency events of default are often wide enough to include circumstances where the borrower enters into negotiations with other creditors with a view to rescheduling indebtedness. Material adverse change may be an event of default. This is relevant where there's any event or circumstance which has occurred in which the lender believes has or may have a material adverse effect on the business, prospects, or the financial condition of the borrower. Material adverse change clauses are often widely drafted because they are intended to cover unpredictable or unforeseen events. A lender may be reluctant to default a loan solely on the basis of a MAC event of default. It's likely that a lender would want to determine that the impact of Covid-19 on the borrower's business will have a sustained adverse effect on the business and will not be temporary. But it may be that the case that a lender will default a loan where they consider that a material adverse change has occurred, coupled with another breach under the facility agreement. Finally, it's recommended that borrowers check the transferability provisions in the loan agreement and check whether or not the lender would have the right to transfer the loan to another party without the borrower's consent, where the borrower is in default under the loan agreement. So moving on to some of the practical considerations for borrowers. Early engagement in these circumstances will be key. Early and open engagement with lenders in relation to potential breaches of finance documents will enable the parties to work together in order to ascertain the true impact of the pandemic on the borrower's business and borrower's financing arrangements, and to work together to ascertain whether any waivers or breaches of the loan agreements are required, or if indeed a more extensive restructuring of the financing arrangements are required. To the extent that any waivers, amendments, or restructurings are required, or to the extent that new facilities required to be entered into, it's important to consider signing logistics. Consider the location of authorised signatories for the business. Do those signatories have access to printers and to scanners to ensure that any documentation which does require to be signed can be signed and returned to the lender in short order. Related to the issue of signing logistics is the question of whether documents can be signed electronically or whether a wet ink original signature is required. Not all documents can be signed electronically, and it is important to check whether a wet ink signature is required. And further guidance on this topic can be found on Brodie's dedicated COVID-19 hub on Brodie's website. Registrations. It may be the case that as a result of any amendments to existing financing arrangements or new financing arrangements that are going to be entered into, that the terms of those arrangements will require parties to undertake registrations at the Land Register of Scotland. As a result of the COVID-19 pandemic, there may be a delay in the parties being able to register documents at the Land Register at this time. Now, it is anticipated that the registers will be able to accept electronic applications in the coming weeks. It is important to check the most up-to-date position if this is relevant, and I'd recommend that you speak to your usual Brodie's contact in order to obtain the most up-to-date position on this. Finally, I'd like to cover some of the government funding schemes which have been introduced to assist borrowers through the high economic impact phase of the pandemic, and when businesses will be experiencing a significant reduction in cash flow and liquidity. The schemes include the Bank of England's COVID Corporate Financing Facility. This scheme is intended to provide support to larger businesses. By offering short-term debt instruments directly to the Bank of England, companies can receive an immediate cash injection. This scheme, however, is only open to businesses which make a material contribution to the UK economy. The government has introduced the Coronavirus Business Interruption Loan Scheme. This scheme offers smaller businesses with an annual turnover of up to 45 million, funding in an amount of up to 5 million. The government will guarantee 80% of the funding. However, importantly, this guarantee is given to the lender, and the business should be aware that they will remain liable for 100% of the borrowing. Under the CBIL scheme, the government will cover the first 12 months of interest payments plus any lender fees, such as arrangement fees. And so it could be advantageous to a number of businesses to take advantage of this scheme. The government has recently announced some important changes to the scheme to open it up to a wider range of businesses who previously would not have been able to take advantage of this scheme. Importantly, sufficient or insufficient security is no longer a condition to access the scheme. And finally, the Coronavirus Large Business Interruption Loan Scheme has recently been announced and will apply for those businesses with a turnover of between 45 million and 500 million per annum, and will offer funding of up to 25 million. Again, this funding will be backed by a government guarantee for 80% of the funding. Further details of this scheme are awaited. However, it is expected that further details will be available by the end of April. For a comprehensive summary of all of the government funding schemes, including eligibility criteria and details of participating lenders, please visit the COVID-19 Hub on Brodie's website, or alternatively, please speak to your usual Brodie's contact who will be able to assist. That concludes this webinar. I hope you found the content useful, and thank you for listening.